present, including 2 members of the minority. The meeting will come to order. We have several items on today's agenda. 3 nominees have been listed on the agenda for the first time and will be held over. Sarah Hill for the District Court of the Northern District of Oklahoma. John David Russell for the U.S. District Court for the Northern District of Oklahoma. Ramona Manglona to the District Court of the Northern Mariana Islands. Today we will again vote on 2 judicial nominees who have been referred back to the committee due to a procedural issue with our previous vote. Given that these nominees have already been debated at length, we will move directly to those votes. We also vote on 3 additional judicial nominees and a Justice Department nominee. The committee will then return to its consideration of the request for authorization for subpoenas related to the committee's investigation into the Supreme Court's ethics standards. Before I turn it over to Ranking Member Graham, let me address the most recent development. On November 13th, the Supreme Court announced that for the first time in its history, it would implement a code of conduct for the justices. This came after the Roberts Court refused to act on this issue for more than 10 years. After a series of heavily reported disclosures involving several justices, and after this committee favorably reported the Supreme Court Ethics, Recusal, and Transparency Act, sponsored by Senator Whitehouse. Among other things, the new code addresses the need for justices to uphold the integrity and independence of the judiciary by avoiding impropriety and the appearance of impropriety. But the court's new code of conduct falls far short of what we would expect from the highest court in the land. First, as this court statement on the code specifically notes, and I quote, "For the most part, these rules are not new." That's a tell. It was the old way of doing things that brought the reputation of the court to a new low in public opinion. Under the court's previous practices, justices accepted lavish gifts and luxury travel from individuals with business before the court without disclosing these gifts. Without a new, stronger ethics regime, how can the public trust that the justices will indeed refrain from such an impropriety in the future? And there is no enforcement mechanism in the court's announcement to hold justices accountable for violating the code. While the code of conduct prohibits the appearance of impropriety, it allows the justice to individually determine whether their own conduct creates such an appearance in the minds of, quote, reasonable members of the public. This is something the justices have repeatedly failed to do over the last few years. Without an enforcement mechanism, this code of conduct, while a step in a positive direction, cannot restore the public's faith in the court. Because of this, congressional action remains appropriate and necessary. The committee's investigation of the court's ethical crisis, and these subpoenas in particular, are key pieces of our legislative effort to establish an effective code of conduct. My Republican colleagues claim our efforts are motivated by my disagreement with the court's recent decisions. But I first asked Chief Justice Roberts in writing to address the court's lack of enforceable code of conduct 11 years ago. And an enforceable code of conduct would apply to all 9 justices appointed by presidents of both parties. One Republican claimed that I am, quote, opening Pandora's box, but I am only seeking subpoenas for 2 people who have refused to comply with this committee's oversight request for months. Contrast this with the Republicans' unprecedented subpoena authorization in 2020 for a Crossfire Hurricane investigation. They provided the chair with blanket authorization to subpoena more than 50 named persons and an unlimited number of unnamed persons. Unlimited. In that case, committee Democrats circulated 22 amendments, 16 of which we offered for a vote. The vast majority of those amendments related directly to the subject matter of the subpoena authorization. In contrast, today, committee Republicans have circulated 177 amendments, the vast majority of which have nothing to do with the Supreme Court ethics crisis. Both Leonard Leo and Harlan Crow are central players in this crisis. Their attempts to thwart the legitimate oversight efforts of the Congress should concern all of us. As I've said before, I do not seek this authorization lightly and do not ask for it often. But to protect Congress's authority and advance the committee's efforts to implement an enforceable code of conduct for the Supreme Court, it is necessary to seek authorization to pursue compulsory process with respect to Mr. Leo and Mr. Crow. Before turning to the ranking member, Senator Graham, for his opening remarks, I will tell you that the standards we will follow and procedure are all precedent of the committee. They have been used by the two previous Republican chairmen, and we can cite the exact date when that happened. Now Senator Graham is recognized.
Thank you, Mr. Chairman. What a difference a day makes. So yesterday, we had 4 Florida judges that came before the committee, where the 2 senators from Florida, both Republicans, reached agreement with the White House to fill judicial vacancies at the district court level. We did 1 in South Carolina. So here we are today. I don't buy anything you just said. Let's just be real blunt and direct. This is garbage. If you really thought this was a problem, why don't you bring up the Supreme Court Ethics, Recusal, and Transparency Act that was passed September the 5th, 2023, in this committee to fix the problem you just talked about. This bill is never going to see the light of the day. Go to Senator Schumer and tell him this is urgent. The country's going to collapse if we don't fix this problem. Why hasn't the majority leader brought up the bill that all of y'all voted for to fix this problem? It's never going to be brought up. These subpoenas are never going to see the light of day. I don't know who's driving the train on your side, but you're driving the committee off into a ditch. So this is a joke, a complete joke. Senator Whitehouse, why can't you convince Senator Schumer to bring the bill up so we can amend it, debate, and vote on it on the floor of the United States Senate? It's the Supreme Court Ethics, Recusal, and Transparency Act. As a matter of fact, next week, I will go down and ask it be brought up. And we'll spend all the time we need as a body to determine what we should do with the Supreme Court. It was a party line vote. All of us voted no because we think it's a really bad idea. This jihad y'all have been on against the Roberts Court is not even, there's transparency. I'll give you credit for that. Here's what you said. I mean, the majority leader of the Senate went to the steps of the Supreme Court and threatened them all. So at least you're honest about what you're trying to do. At least you were before. I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you've unleashed the whirlwind and you will pay the price. I guess this is the price the Supreme Court's paying for offending you. So your response to the court you don't like is to try to basically take over how the court works in terms of their internal policing themselves about ethics matters, which all of us on our side feel like really uncomfortable because they're a separate branch of the government. And they did pass some rules that move in the right direction. But you want to pack the court. When you say you don't want to destroy the Roberts Court, I don't believe you. I don't believe a word you're saying. If it were up to you, there would be 13 members on the court, 15 members on the court to dilute the Roberts Court. So you are trying to restructure the court. This is just another way to do it. And is there a consequence to all this rhetoric? Yeah. If you don't believe me, ask Judge Kavanaugh. Based on this idea, you've unleashed a whirlwind, we're going to come after you. Some nut job was caught outside of Justice Kavanaugh's home with a tactical knife, a Glock pistol, 2 magazines, pepper spray, zip ties, a screwdriver, a nail punch, a crowbar, and duct tape. But we're going to keep going, apparently. It's not enough. We can work together on social media where we all agree there's being abuse, and we all work together to do subpoenas. The reason I think this is a bunch of garbage and crap, to be honest with you, is I don't think you're remotely interested in bringing up the bill that passed the Senate Judiciary Committee. If you really cared about this, we'd be on the floor a long time ago debating fixing this problem. You know you're not going to get 60 votes for these subpoenas. I don't know who you're trying to please. I don't know what group is going to feel better because we're doing this on your side. But you're pleasing like none of us. And this committee has functioned fairly well given what's going on in America today. So no, I don't buy one bit. This is about fixing a problem. This is about an ongoing effort to destroy this court, to destroy Clarence Thomas's reputation, to pack the court, to get your way, to make sure the Supreme Court exists today, can't function. The Democrats need to destroy Clarence Thomas's reputation. I'm not a real reader of the New Republic, but I think a lot of people on your side probably do. And this is what you're trying to do, and you're going to meet a real brick wall over here. And this is going to fundamentally change the way the committee operates. And it's a choice you made. Live with your choice. I'll end where I started. If you think this is a problem, bring up the bill passed by the committee. You have the power to do it. You're never going to do it because you know a lot of your own members won't support this. You know it's not going to work. You're trying to please a group. You're not trying to make this committee function.
Before moving to the subpoena authorization, we'll consider the nominees. First is Judge Mustafa Kashubai, nominated to the U.S. District Court for the District of Oregon. The clerk will call the roll.
Mr. Chairman, are we going to have an opportunity to speak on the nominees?
Yes, we're going to, oh, I'm sorry. We already had done that at great length.
Well, I think this deserves some commentary, given the nature of the nominee, and I'd like to ask to speak on the nomination.
Senator, we've debated these two nominees twice.
Mr. Chairman, I would also like to speak on the nomination.
I understand what you'd like to do, but I'm saying that in fairness, we have debated these nominees twice, and I ask the clerk to call the roll.
Mr. Chairman,
Mr.
you're
Chairman.
denying us an
right.
opportunity to
Mr.
speak
Come
on a
on, man.
nominee?
I mean,
Third time, no.
okay, do this.
So
Just
we don't
do
have
it.
a right to speak under the rules?
Under the third time, I'd say no.
So you're just going to make it up?
So yeah.
I'd like to
There's going to be a lot of
speak
consequences
I'd like
coming
to
here.
speak too, Mr.
You're going to have a
Chairman.
lot of consequences coming if you go down this road.
You better
I've
believe
cautioned
it.
you. I've cautioned a lot of you.
The clerk will call the roll.
Listen to me. I've cautioned a lot of you.
Mr. Chairman,
Mr. Chairman, don't we get the opportunity to speak?
We're in a roll call.
So you're
Even,
telling
even
us
though
to shut up?
even though multiple
You
members
want
have
us
asked to
to
speak,
shut up? Is that what you're saying?
A lot of people didn't speak on the two nominees before.
We've done,
I
Would
would,
you raise your hand if you did not speak?
I did not have a
Senator
Okay.
Corn didn't even have a chance to speak.
Senator Blackburn had a chance to speak.
we've got several folks, Mr. Chairman, who didn't have a chance to speak.
We want to tell you again why these nominees are awful.
Or in Senator Corn's case, tell you for the first time. You're just going to sit there and ignore us?
Senator Blackburn, have you spoken on these nominees?
I've not had the
you like
opportunity to
to?
speak. I would like very much to speak on Mr.
Mr. Chairman,
Kassabai.
I urge you to let Senator Blackburn speak.
Senator Corn as well. Senator Corn hasn't had a chance to speak.
That's correct.
Point of order, Mr. Chairman. You can't limit debate without invoking Rule 4. You haven't done that.
we have debated,
We've debated on prior occasions when we didn't have a quorum. That vote didn't count. We've got people who are here now who weren't here then who would like to speak.
Can we speak on the other nominees?
Or is your plan just to end all debate today? Is your plan to end all debate? Do you have an answer? You're going to rely on someone whispering in your ear. What's your plan?
No.
No, we're not. Okay, listen, here's the deal. We worked 7 weeks to try to solution the asylum problems. You boycotted the committee.
Mr. Chairman, I don't know if you've left us any alternative but to deny the committee a quorum. I think that's something we ought to seriously
I tell
consider.
you what.
Mr. Cotton says the chairman needs to rethink his decision
Yeah,
and let Senator Corn and Senator Blackburn speak. That's what Mr. Cotton says. You can mark that down as my vote.
Yeah,
And everybody over there who's not willing to look at me or look at Dick Durbin needs to think about it as well. Mr. Kennedy wants to speak as well. Mark Mr. Cotton down saying Mr. Kennedy needs to speak too.
I'm waiting to be heard on the nominee. I've requested several times to be heard on the nominee.
So no, I guess Senator Durbin's not going to allow women to speak either. I thought that was sacrosanct in your party.
aye. The nomination will be favorably reported to the floor. Up next is Judge Yumi Lee, nominated to the U.S. District Court for the,
Mr. Chairman,
Who has not been allowed to speak on that nominee?
Mr. Chairman, you just destroyed
Yeah.
one of the most important committees in the United States Senate.
Chair would note.
And you set a precedent,
The chair
which
would
will
note-
be repeated every time one party or the other takes advantage and takes the low road.
Chair will note
It
that
sets a
both nominees
precedent
have
that
been
will then
debated twice.
become the norm.
Kashibai and
Congratulations on destroying the United States Senate Judiciary Committee.
Up next is Judge Yumi Lee, nominated to the U.S. District Court for the Northern
Who
District
has
of
not
California.
spoken on this nominee?
Clerk will call the roll.
Will you raise your hand? Look at all these people have never said a word before you make them vote. Never said a word before you make them vote.
Just going along with it. Just going along with it.
You know, when
Mr.
we were in
Coons
the
said he would
majority,
allow members to speak.
Mr. Chairman, when we were in the majority, we allowed Democrats to speak ad nauseum, at great length. We never did this.
Both of these nominees have had 2 opportunities for speeches by members.
Mr., you have to bring them up again. It wasn't our fault, it's your fault.
Mr. Ossoff.
Going right along with it.
Mr. Welch. Ms. Butler.
Mr. Chairman, I hope you're proud of yourself.
Is this guy talking to Dick Durbin, the chairman?
Yeah, you really have. I don't know what drives this, Dick. I really don't.
Mr. Chairman, is it you driving it, or is it your staff
Yeah, is Joe
driving it?
Zogby the
Or is
chairman
it
of this
the
committee, or
White
is it
House
you?
driving this? This is completely inappropriate not to let us be heard on these nominations, and you know that.
Mr. Graff.
Your own members have told you to let them speak.
Mr. Cornett. Mr. Cornett. Mr. Lee. Mr. Cruz.
This is a complete disgrace.
Maybe you can share
I
with us.
see my colleagues over here who understand what goes around comes around.
I mean, this is so unnecessary to ruin the committee over a political exercise that's going nowhere. Senator Whitehouse,
I would like to, was my name called? I can't hear. Where's that voice?
Was he recognized to speak?
We're on a roll call.
Ma'am? I'd like to speak, please.
We're on a roll call.
Mr. Tillis. Mrs. Blackburn.
I'm waiting to be heard on the nominations.
Mr. Coons.
Is this an illegal vote?
Chair Durbin.
So now Joe Zogby is going to dictate to other senators how they're going to vote?
On this vote, the ayes are 10.
The nomination will be favorably reported. We now turn to nominations that have not been debated before the committee, and the committee is open to
Mr.
conversation.
Chairman, I seek to speak on Seth Aframe.
Well, that is the next nominee, and you are
And-
recognized.
And I thank you for that. I have made it clear that I will not support this nomination, and there is a good reason for not supporting him, Mr. Chairman. The White House really does not have a good record when it comes to this seat. Back in February, I voiced my opposition to Mr. Delaney, Michael Delaney, who was nominated for this very same seat. Well, Mr. Delaney, we found out, had used hardball tactics against a 15-year-old survivor of sexual assault. He did this in order to protect an elite private school that wanted to cover up the disgusting conduct that had been perpetrated against this young woman. Now, Mr. Delaney threatened to name, to shame, and to humiliate her by removing her anonymity if she had the audacity to come forward and tell her story. Now, fortunately, at least one of my Democratic colleagues had the moral clarity to join us in sinking Mr. Delaney's nomination. Now, after the Delaney debacle, you would think that the White House would have learned their lesson. And I thought they would have the decency to nominate someone who actually had a track record of protecting women and children, and it seems I was wrong. The president has chosen to nominate someone very similar to Mr. Delaney and his disregard for the well-being of children, and that is Seth Aframe. And I recently spoke on the Senate floor about this nomination, so I'd like to walk my colleagues through the two cases that Mr. Aframe prosecuted that automatically, in my opinion, automatically disqualify him from service on the federal bench. Now, in each of these two cases, Mr. Aframe recommended sentences far lower than the guidelines for heinous, unimaginable crimes against children. One of the defendants was guilty of unconscionable acts of sexual violence against a 14-year-old girl with a hearing impairment. This precious child was kidnapped. She was taken to an abandoned motel in Vermont, and she was raped. Despite all of this, despite what happened to this child, Mr. Aframe, as the prosecutor in this case, recommended a sentence far below the probation officer's suggested guidelines. It is clear that Mr. Aframe wanted a low sentence. And let me read you why. And these are his words. He wrote, and I'm quoting, "This low sentence will incapacitate the defendant until he is in his 60s. Hopefully, by that time, the danger that the defendant presents will have subsided." End quote. Mr. Chairman, that is repulsive. It is disgusting. And you have a 14-year-old girl that was hearing impaired that was forced to go through this rape and this sexual violence with a man, and then you've got a judge who says, well, maybe by the time he's in his 60s, he will not want to do that anymore. That is disqualifying from someone to sit on the federal bench. What is a woman? What is a girl? What are they going to think when they go before this man? Now, the other case that I want to bring up, the defendant in the other case had created 6 videos of himself sexually abusing a 3-year-old girl, 3 years old. Now, many of us are parents and grandparents. I want you to think about this. Think about a 3-year-old girl being sexually abused, not once, not twice, not 3, not 4, not 5, 6 different times. 6. Think about this. This is a 3-year-old toddler. How many of you have 3-year-olds in your lives? I do. To me, this is repulsive. So let's talk about the sentence in this case. Well, Mr. Aframe decided he was going to recommend 60 years, but what was the sentencing guideline on this? It was life in prison. If he had given him life in prison, he wasn't going anywhere. He was locked up. 60 years, well, maybe the guy can get probation. So Mr. Aframe himself noted in the sentencing memo that he was asking for something lower than life in prison. When I pressed Mr. Ephraim about this under oath on why he refused to recommend life in prison, he misrepresented the facts. So let me again set the record straight. The sentencing memo that Mr. Ephraim wrote himself stated that the guidelines recommend a sentence of life in prison for raping this child. That, Mr. Chairman, is a fact. Regardless of what your staff is whispering in your ears, that is a fact. So I am going to ask my Democratic colleagues to join me in voting no on Seth Ephraim. The man is morally unfit to sit on the federal bench.
Mr. Chairman, may I speak on this?
Of course, Senator Graham's recognized.
Thank you. When I had a discussion with Mr. Ephraim, as I recall it, this idea you age out in terms of being whatever you want to call the guy was unnerving to me. I am never going to put somebody in a position of legal authority who believes and hopes that by the time one of these pedophile types are in their 60s, they are no longer a threat. I hope you all understand his reasoning here. There is no information that I know of to suggest that makes any scientific sense. Just think about what I said. We're about to put a man on the Court of Appeals who, when he was in the trenches, justified a sentence that was under what it should be based on the idea that by the time he gets in his 60s, hopefully he will not be a threat. The best way to make sure that that logic doesn't infiltrate the American legal system is to deny this man a position of responsibility, of high responsibility. This would be the last guy I would entrust with responsibility of our legal system based on that single statement and the reasoning behind it.
Anyone else seek recognition? Senator Cotton?
Mr. Chairman, I'd also like to make a few comments on the nomination of Seth Ephraim. I hear talk about Mr. Ephraim having been a prosecutor as if he's somehow tough on crime. But even when he's supposed to be the criminal's adversary in court, he finds a soft spot for them. For example, in one particularly heinous child pornography case, Mr. Ephraim refused to recommend a life sentence for the abuser, even though that's the sentence called for by the sentencing guidelines. Instead, Mr. Ephraim asked to reduce the sentence to 60 years and give the criminal supervised release instead. Now, that may seem like a long time, but honestly, even a life sentence, or as far as I'm concerned, the death penalty, would have been far too lenient for this depraved criminal. We're talking about a criminal who filmed himself raping a 3-year-old girl. Let me repeat that, raping a 3-year-old girl, after he spent years having gotten close enough to her family that they even consider him as a potential legal guardian for their daughters. The details of the case are much more heinous than just that. I know some Democrats on the committee think that child pornography laws are too harsh. They're wrong about that, but we're not talking about some minor child pornography offender here, someone who happened to have an image on a computer. We're talking about producing, making the worst, most depraved, heinous, imaginable child pornography and infiltrating the home and family of his victims to do it. Somehow, though, Mr. Ephraim thought that this criminal deserved leniency and refused to ask for even the recommended sentence for his crimes. So I ask my Democratic colleagues, are you on the side of Mr. Ephraim or a 3-year-old girl who was violently raped?
Anyone else seek recognition on this nomination? Senator Kennedy.
Mr. Chairman, can you hear me? Could you give, I won't say us, I'll just say me, an explanation of the legal basis on which you denied us the right to debate the first two nominees?
Thank you, Senator. I'm happy to do that. The two preceding chairs of this committee violated the letter and spirit of Committee Rule 4. Without any affirmative votes from Democrats, they set a time certain for vote on nominees and legislation, ending debate without adhering to Rule 4. Then Chair Grassley did so with nomination vote on then Judge Brett Kavanaugh of the Supreme Court, and then Chair Graham did so with a partisan immigration bill. In doing so, Republicans established a new precedent that I followed on one occasion last Congress and will follow again today. I've said time and again there cannot be one set of rules for Republicans and a different set for Democrats. In this instance, the two nominations in question have been brought before the committee just as this nominee is, and members have been given opportunity to speak if they want to attend and speak. We did it twice. This is the third time they were brought up, and that's the reason the ruling was made by the chair.
Well, Mr. Chairman,
If I could just finish, could I
Yeah,
just
go ahead.
So, Mr. Chairman, you're saying because you think that Senator Grassley violated the rule, you're going to violate the rule?
It's called precedent, Senator.
No, it's called two wrongs don't make a right, but they do make it even. I'd like to hear what Senator Grassley has to say. I mean, you accused him of violating the rule, and my guess is he doesn't agree with you.
All I can say is that what happened the days that we were involved with Kavanaugh, there wasn't any effort to stymie Democrats from saying everything they wanted to say, and we sat there and listened to them, and then we had a day before we voted.
And I believe you said one other Republican chairman violated the rules. Would that be Senator Graham?
Yes.
Senator Graham, did you violate the rules?
We're talking about legislation,
Right,
not nominations.
right.
For 7 weeks, I begged my Democratic colleagues to work with me to find a change to the asylum system. They boycotted once or twice the ability to move the legislation forward.
Excuse me for interrupting, but what do you mean by boycotting?
They didn't show up. They denied us a quorum. Senator Feinstein came. And the same group of people are refusing to do things necessary to secure the board. This was a 2019, Senator Kennedy.
Yes, sir.
We're trying to find a way to stop a problem, working together. The response was to boycott the markup, but we're talking about legislation. The nominations were brought back to the committee because the parliamentarian ruled that the way the committee conducted the nominations violated the rules. It wasn't me. I didn't ask these two people to come back. But the underlying problem, let's just get to it. We're talking about subpoenas, not legislation. Rule 26 doesn't cover this. You're basically, we will be. What drives all this is how we feel about this never-ending effort to delegitimize this court. And the reason I think this thing is a charade is because the bill that was passed by the committee in September, Supreme Court Ethics, Recusal, and Transparency Act, has never been brought up. And all of us know you don't have 60 votes to subpoena the people you want to subpoena. Months have gone by since this thing was first brought up. So this is the future of the committee, right here, you see it. This is the way it's going to be because you chose to please some group who I don't know who they are, to use the committee to push their agenda in a way that I think is destructive to the court. And when we have a vote on the subpoena, it will be a violation of Rule 4. Because Rule 26 in my view, doesn't cover the subpoena vote. So you can't just act like there's nothing else going on in the committee. I have tried, as the ranking member, to my own detriment, to get things moving through the committee because I realize that elections matter. Those days are over. Kavanaugh, I vote for Sotomayor and Kagan and get repaid by the most disgusting display of hatred and partisanship against a nominee I've ever seen. It's always our people who have their lives turned upside down. Senator Grassley allowed Dr. Blasey Ford to come into the committee. Every time something new came up, we had another hearing and another hearing and another hearing. And when we voted on the nominee, you had information about Ms. Ford and you never shared it with the nominee. We read about it in the Washington Post. This was an effort to ambush the guy, and it didn't work. So you made a choice here. And I'm going to go to the floor and ask that this bill that we passed in September come to the floor, and it never will. And when we had when we had subpoenas to be issued regarding Crossfire Hurricane, the biggest abuse of the rule of law since I have been here, people using fake information to get warrants against American citizens, the FBI running every stop sign known to man. You had votes when we issued those subpoenas. I think 26 or 16. So the bottom line, Mr. Chairman, you made a choice, and it was a bad choice. You assume things you can't assume anymore. You assume that we're just going to act like nothing happened. I have told you personally and privately, Senator Whitehouse and I have done a lot of good things together. Consider him a friend, but I consider this unacceptable. I consider this taking good intentions and turning it around in a bad way. So I hate this. I hate it more than you'll ever know, but here we are. And to my friends on the other side, you have made a terrible decision today.
Senator Kennedy, one other point I would like to make on those first two nominations. After we had an open opportunity for debate in the committee, and it did have a roll call, something occurred which was news to me. Have you ever voted proxy in a committee and then arrived a few minutes later and said, I want to be recorded as voting present? And with unanimous consent, there's never been an objection. There was an objection from the Republican side of the aisle to the parliamentarian. That's why we had to take an additional roll call vote on the first two nominees. So it wasn't just a happenstance. It was a circumstance that was created beyond our control. And
Mr. Chairman,
I understand, Dick, or Mr. Chairman, but I'd like you to consider this. I don't understand why you're taking this new approach. I enjoy this committee. We all take our responsibility seriously. I can only speak for me. I try to be fair-minded. I voted for a number of President Biden's nominees when I think they're qualified. And I try to ask substantive questions. I did the same thing with President Trump's nominees. In fact, we killed 5 of President Trump's nominees because we killed them dead as 4 o'clock because it was apparent after questioning them that they didn't know a law book from a Sears Roebuck catalog. And we killed them. And I think we, on our side of the aisle, my side of the aisle, have voted for more of President Biden's nominees than my Democratic colleagues have voted for President Trump's nominees. No, that's okay. Everybody has one vote, and they have the right to exercise. I know you don't like some of my questions. I get that. And some of your comments have been borderline snarky, but I ignore them. When my son was going through puberty, he used to make those comments, and I learned that, it's the best thing to do is just ignore him. But I just don't understand why you're taking us down this road. I don't. The last time we met, you preached cooperation, and I think we've been cooperating. I think we confirmed more Louisiana nominees than just about any other state. There were some people who were not here at the last hearing that would like to speak on, and would have liked to speak on Mr. Khashoggi. I did speak, and I'm willing to waive my right to speak again. But this is a gentleman who said that he believes that when race is an issue in a case, that he has the right to ignore precedent in the federal rules of evidence and the federal rules of civil procedure and apply a new standard of proof. Now, some people find that objectionable. I do. And I think folks should have had the right to weigh in on it. And I confess, I don't understand why you're taking us down this road. I don't. And the final point I guess I would make is that I asked you this question last time, and I think if where you're headed with this is to ultimately subpoena Justice Thomas or another member of the Supreme Court, I think that would be a huge mistake. But if that's where we're going to go with this, I respectfully suggest you go ahead and do it and let us meet it head on, because that looks to me like where it's headed. And I think it will provoke a constitutional crisis, and let's just go ahead and meet it head on. So thank you for the chance to respond, Mr. Chair.
Else wish to speak on this nomination?
Mr. Chairman, for the record, it wasn't some esoteric rule. You didn't have a majority present the last time we voted on these judges. That's a widely known rule. It's not some obscure technicality. Incompetence on your part does not override the prerogatives of senators on our part.
It's the first time, Senator Cotton, that there's ever been an objection when a proxy vote asked to be recorded as a vote present, physically present. And I just say all of us, because of our schedules, face this all of the time. And this is the first time I've seen it in the time that I've served in the United States
And the
Senate.
parliamentarian ruled against you. And it looks like Senator Graham has something to say.
Yeah, I do.
Do you recognize Senator Graham?
He can take the rest of my time if he wants it.
Yeah, so here's the deal. These two nominees are like historically bad. I would do anything I could to keep them off the bench. But in terms of what the parliamentarian ruled, she did it, and here we are. There are rules, but the point I'm trying to make, Mr. Chairman, is that the consequences of this to the committee are just far outweigh, I think, any benefit. Because I don't believe your side when you say you're not out to get the court. If it really were about fixing the ethics problems of the court as you see them, why haven't we taken up the legislation the committee passed? Why can't you get Senator Schumer to bring the bill up that supposedly fixes this? It's never going to be brought up. You know why it's not going to be brought up? Because it's not going to pass. It's unconstitutional. It's a bad idea. So I'm going to keep making that point. I don't buy what you're saying. If this really were the issue you claim it to be, then we will have voted on the bill passed by this committee a long time ago. We're never going to vote on that bill, folks. It's all political theater at the expense of this committee. You've made a choice. Accept the consequences.
On favorably reporting the nomination of Seth Robert A. Frame to be U.S. Circuit Judge for the First Circuit, the clerk will call the roll.
Mr. Whitehouse.
Aye.
Ms. Klobuchar. Mr. Coons. Ms. Serrano. Mr. Booker. Ayes are 11, the nays are 10.
The nomination will be favorably reported to the floor. Up next is Judge Edward Keel, nominated to the U.S. District Court for the District of New Jersey. Does anyone seek recognition to speak on this nomination? If not, the clerk will call the roll.
Mr. Whitehouse.
Aye.
Ms. Klobuchar. Aye. Mr. Coons. Aye. Mr. Blumenthal. Aye. Ms. Serrano. Aye. Mr. Booker. Aye. Mr. Padilla. Aye. Mr. Ossoff. Aye. Mr. Welch. Aye. Ms. Butler. Aye. Mr. Graham.
No.
Mr. Grassley.
No.
Mr. Cornish. No. Mr. Lee. No. Mr. Cruz.
No by proxy.
Mr. Hawley.
No by proxy.
Mr. Cotton. No. Mr. Kennedy. No. Mr. Tillis. No. Mrs. Blackburn. No. Chair Durbin.
Aye.
Chair Durbin, on this vote, the ayes are 11, the nays are 10.
The nomination will be favorably reported to the floor. Up next is Sarah Russell, nominated to the U.S. District Court for the District of Connecticut. Does anyone seek recognition? Senator Lee is recognized.
Mr. Chairman, I've got some concerns with regard to this nominee. He's made some statements that I think are incompatible with someone wanting to serve as a life-tenured Article III federal judge. During the height of COVID, one of my many concerns relates to a letter that she signed on to. A letter that reflects a certain betrayal, in turn reflecting a lack of judicial temperament. The letter that she signed on to is captioned, "Urgent action needed to protect individuals in Connecticut's prisons and jails from coronavirus 19." It called out on the governor of the state of Connecticut and all Connecticut jurisdictions to, number one, immediately release to the maximum extent possible, this is a quote here, people incarcerated pre-trial and post-conviction. Also said that, even post-conviction, the governor should release as many people incarcerated post-conviction as possible, including but not limited to all people over the age of 55. And by that standard, if that somehow entitles you to compassionate release, nearly every committee member here would be subject to that, and it doesn't seem that old to me. Individuals who have uncontrolled diabetes, respiratory conditions, and/or immunocompromised, and all people who are eligible for parole and community supervision or release, or who are currently incarcerated for technical parole or probation violations. In addition, it argued that the state should declare a moratorium on incarceration, a complete moratorium, and urged the governor to issue an executive order directing the state's attorney and law enforcement entities, including town and city departments and so forth, to immediately cease adding to the incarcerated population, given the high risk of infection posed by population increase, both to those already incarcerated and to those entering correctional facilities. So in other words, they're basically declaring a sort of an incarceration holiday. You think of the message that sent at the time. You commit a crime in the state of Connecticut, you're just not going to be thrown in prison. Why? Well, because COVID. And then it also asked for for all policing and arrest practices to be changed in order to reflect the moratorium on incarceration. Now, these are not my words, these are the words of the letter. A moratorium on incarceration. Think about what that means. It reminds me of the scene in the movie Lion King when they're talking about the fact that there would be no king. and the absolute anarchy would prevail. For instance, best practices across the medical field in times of crisis recommend stockpiling at least 2 weeks and 3 months of supplies. And so they were going to have all of these policing policies changed to that extent. Harm reduction organizations are globally advocating that people dependent on substances also ensure they have accessible several weeks supply to prevent the potentially severe effects of withdrawal at a time with even less capacity for adequate treatment. Suggests to me that I don't know whether she's suggesting keeping people doped up so that they don't have to detox if they're incarcerated at the time, or not incarcerating them at all. But again, when you're declaring a moratorium on incarceration, that seems to be what they're suggesting. In those circumstances, is it appropriate? I can't think of a circumstance, even at the worst time of panic during COVID, when people committed to the rule of law thought that it was important not to make arrests or to sentence people to prison, send them to jail or to prison as a precaution against COVID. People who commit criminal acts should never receive the message that there's going to be no consequence. And I think someone who has reflected that kind of profound lack of judgment by signing on to a letter like this, a letter that I would add, if I'm not mistaken, was not properly disclosed to the committee on the nominee's part. We've got a major concern with this nominee, and I can't support this nominee's confirmation.
Anyone else
Chairman.
seek recognition? Senator Kennedy.
Yes, thank you, Mr. Chairman. Ms. Russell sent a letter to the governor of Connecticut during the pandemic. Here's what she said, quote, "As they stand, prisons and jails are detrimental to public health and human rights and disproportionately harm marginalized communities, including Black, brown, indigenous, and other communities of color, immigrants, people with mental illness, people with disabilities, people in the LGBTQ plus community, people who use drugs, people engaged in sex work and street economies, and people experiencing houselessness and poverty." Then she went on to request the governor to immediately release everybody in jail in Connecticut. It's unclear to me whether she was talking about just during the pandemic or on a permanent basis. Then she goes on to tell the governor of Connecticut to stop putting people in jail. And it's still unclear to me whether she meant just for the duration of the pandemic or on an extended basis. And on top of all of that, the cherry on top, she didn't turn the letter over to the committee. I don't know why she didn't. Perhaps she thought, I'm not saying this is the case, she thought we wouldn't find it. It took about 7.3 minutes on Google to find it. Now, this is America. Ms. Russell has a constitutional right to believe in these things and to say those things. She does not have a constitutional right to be a federal judge. And she's not qualified to be a federal judge if those are her beliefs. How can she possibly, how can any criminal defendant in front of her or any prosecutor in front of her think that they're getting a fair shake in light of this letter when she sentences someone to prison, if she ever does sentence someone to prison. It's just simply breathtaking. And for that reason, Mr. Chairman, I'm going to be voting no.
Mr.
Anyone
Chairman.
else seek recognition?
Mr. Chairman.
Senator Blumenthal?
Thank you, Mr. Chairman. I thank my colleagues on the other side for those comments, which really don't call into question the fundamental credentials and qualifications of this nominee, which are extraordinary. As to the letter, Senator Kennedy, those are not her beliefs. In fact, in response to questions raised during her hearing, she stated in a supplemental statement, and I'm going to quote her, "The letter does not accurately reflect my views. In particular, the letter's suggestions were overbroad and failed to make expressly clear that all decisions about whether to incarcerate people and whether to release people who are already incarcerated must be conducted in a manner consistent with the law and public safety of people and communities." She goes on to cite the specific statutes that would have to be followed by her as a district judge in sentencing or in releasing someone. And she also expresses regret for failing to submit that letter, acknowledging that it should have been. She made a mistake, and she acknowledges it. I think that the views expressed in that letter, which was signed by hundreds, it was a mass letter, not written by her alone. She has, in effect, disowned, saying that they are stated too broadly. And I would urge my colleagues to look to the qualifications of this nominee, which are extraordinarily
Would the
distinguished.
senator yield for a question?
Mr. Chairman, my name was invoked. Can I respond just quickly?
Senator Kennedy?
I appreciate Senator Blumenthal's comments. But Richard, here's how I see it. She got caught. She got caught. She had an epiphany once she got caught. And I am looking at her qualifications, and I am looking at her record. And I don't know that she didn't help write this letter. I know she signed it, and I know she tried to hide it from this committee. So even if you agree with her that we should stop, that actions have no consequences, and that nobody's ever responsible anymore, and it's always somebody else's fault when a criminal sodomizes a young girl, and everybody ought to get a trophy. I mean, I wish we lived in a world like that, but that's what she believes. And you know it, and I know it. And she has recanted after she got caught, and she got caught because she didn't turn it over to us, for God's sakes. Senator, we had to find it on our own. Shame on her. And every single time when she has got to, on the federal bench, she has got to sentence a criminal defendant, this is going to be grounds for appeal. For God's sakes, does the rule of law mean nothing?
The
I'm
senator
sorry,
yield for a
Senator.
question?
Certainly I do, Senator, and I apologize for not yielding.
that's-
Senator.
Chair recognizes Senator Cornyn.
Thank you for yielding for the question. Is the senator from Louisiana familiar with a concept called confirmation conversion? Kind of like a deathbed.
I would like to hear
conversion.
more about it, Senator.
Well, I'd just be interested, how can you reconcile the letter with what Senator Blumenthal, the senator from Connecticut, read as her disavowal of the letter? Did she express regret, or that she had misspoken, or that she now, on second thought, had different ideas? I'm trying to get my head around how do you reconcile this letter that you read from the statement that the senator from Connecticut.
Well, Senator, here's how I reconcile it. 3 words: she got caught. she got caught. And we found the letter, and she didn't turn it over. And during committee, instead of saying, yeah, I signed the letter, and I shouldn't have done it, I don't believe that. First, she said she wasn't sure. And then she was sure. And then she didn't mean it. And then she'll make a pinky promise that she'll be a fair federal judge. These positions are for life. They're there forever. At a minimum, just because you've seen My Cousin Vinny doesn't qualify you to be on the federal bench. At a minimum, there ought to be a minimum level of integrity and a minimum level of adherence to the rule of law. And this lady sets a new standard. And I wish you didn't have to say that, but those are the facts.
Would the senator yield for one last question?
Of course.
Are you familiar with the fact that all federal judges are subject to a code of judicial conduct?
Yes, sir.
That would be all federal judges, correct?
Yes, sir.
Including members of the United States Supreme Court.
Yes, sir.
And is the senator aware of the fact that that code of judicial conduct that applies to all federal judges was actually promulgated in 1919?
Yes, sir. I understand that's the case.
And I'm trying to reconcile the chairman's statement that this code of judicial conduct that applies to the Supreme Court specifically, that was issued on November the 13th, that was the first time that members of the Supreme Court were subject to a code of judicial conduct. Isn't it the fact that the code of judicial conduct that applied to all federal judges applied to them as well?
Yes, sir.
And one of those, how can a litigant, a citizen accused of a crime, somebody who goes to court to seek vindication for a wrong done to them, how can they have any confidence whatsoever in a judge that won't tell the truth?
They can't. And shame on us for allowing someone like that to get on the federal bench.
Now, we've talked a little bit about judicial independence here. I think I agree with those people over time, over the last 230 years or so, who've said that the independence of the judiciary in the United States is a single most distinguishing feature of our form of government, because ultimately people are going to be held accountable, and not for political reasons, not because of their unpopular point of view, but because a judge in some court, perhaps with an appeal to an intermediate court and maybe the Supreme Court, has said, you were wrong and the other side was right. But we also said that these judges should be independent of politics. That's why they get lifetime appointments. That's why the Constitution says their salary cannot be diminished while they serve in office. So what recourse does a litigant, a citizen accused of a crime, or the prosecutor who's representing the state or perhaps the United States, what recourse do they have against somebody who's confirmed as a federal judge who won't tell the truth?
It's a mystery to me, and we're creating a real problem here, in my opinion, Senator. And a real problem for the efficient operation of our court. I mean, if I'm a criminal defendant or a criminal defense attorney, I'm going to do everything I can to try to get this lady as my judge. And if I'm a prosecutor, I'm going to try to avoid her, and I think this letter may very well be grounds for appeal in every single solitary case. I mean, she says it here. Big as Dallas. I don't believe in putting people in jail. if they're part of this particular group that she deems virtuous. Now, if you're not in her group of people that she deems underprivileged and virtuous, you're really at risk, apparently. But if you can fit yourself into, if you can somehow become black, brown, indigenous, an immigrant, people with mental illness, people with disabilities, people in the LGBTQ plus community, people who use drugs, if you can convince the judge that you have been engaged in sex work and street economies, or you are homeless or poor, then she thinks you should not be in jail.
I've heard it said that the single most powerful public official in the United States is a individual federal judge. Have you heard that?
Yes, sir. I think that's.
And what recourse does Congress have to a federal judge who blatantly disregards their obligations under the law? Do we have the authority to force them to recuse or disqualify them? Isn't it fact that given the constitutional independence of the judiciary, the sole recourse that Congress has, I'm not talking about the litigants, that Congress would have would be to impeach, for the House to impeach and the Senate to convict them in a court of impeachment. Isn't that right?
That is correct, and that's why I've always been so proud to sit on this committee, because our job is to stop people from getting on the bench who are whack jobs.
And that same limitation of remedy that Congress would have would also apply to a United States Supreme Court justice, correct?
Yes, sir.
Impeachment by the House, conviction in the Senate, and removal from office. That's the sole remedy, correct?
Yes, sir.
Blumenthal.
Thank you, Mr. Chairman. I think this colloquy has gone pretty far afield. I don't think it merits response. I'll ask for the vote.
Mr. Chairman?
Senator Cruz?
Yes.
Welcome. Proceed.
Mr. Chairman, in 1964, Ronald Reagan gave what is now an immortal speech called A Time for Choosing. I think on this committee, we find ourselves similarly in a time for choosing. The senator from Connecticut is trying valiantly to rehabilitate this nominee. And the arguments he's presenting are essentially, well, she's not all that bright. She didn't really read the letter. She didn't really know what was in it. She signed it, but she didn't mean to sign it. And if she'd known what was in it, she wouldn't have signed it. Now, that's the defense of her. Remember, we're talking about whether this person is fit to be a federal judge. And if the best defense is she's too dumb to figure out what she signed and she didn't mean to sign it, didn't read it, and didn't know what it said, that doesn't give you a whole lot of comfort, the kind of job she'd do if she's wearing a black robe and signing death warrants. Maybe she ought to read the piece of paper in front of her. And by the way, this is not some writing from 30 years ago when she was in college. This was written March 16th, 2020, 3 years ago. It's recent. I don't believe it's an accident that she didn't turn it over. She knew damn well this is a radical document. And look, the notion that she did not understand what it meant, I'm holding it in my hand. Let me read you. I'm just going to read you from the very beginning, because let's see if it's subtle. Let's see if they hide the ball, what it talks about. Here are the opening words of the letter. The undersigned organizations and individuals call on Governor Lamont to act immediately to protect the lives of the incarcerated people in our state. 3 urgent steps are needed. 1, the immediate release of as many people in custody as possible. 2, a moratorium on new admissions into jails and prisons. And 3, evidence-based, humane, and and rights-affirming measures to protect the health and well-being of the individuals who will stay behind walls. That's the opening paragraph. It ain't subtle. To my friend from Connecticut, if she's not bright enough to figure out this letter is saying, let the criminals go, When it says in the opening paragraph, we demand right now you let the criminals go, then she needs to go back to remedial English in 5th grade and not become a federal judge. By the way, the letter goes on and on and on. You go into the body of the letter. We call on Governor Lamont, the state of Connecticut, to, 1, immediately release, to the maximum extent possible, people incarcerated pre-trial and post-conviction. On pre-trial release, here's what it says. Governor Lamont should use his emergency powers to protect incarcerated people, their communities, and correctional staff by releasing all, ALL, all people who are incarcerated without having been convicted of a crime. I want you to stop and understand what those words mean. All people means everyone. It means every murderer in the state of Texas. If you have a serial killer who has raped and murdered a dozen women on the highways of Connecticut and he's arrested, what did this woman call for? Let him go. If it's pre-conviction, let the serial killer go. If you have an aggravated rapist, if you have a child molester, there's no conditionality about, well, only nonviolent. No, it doesn't say nonviolent. It says all. Let every single criminal go pre-conviction. Look, I understand this is Washington, D.C., and there's politics here. And there are a lot of issues on which Democrats vote with Democrats, Republicans vote with Republicans. We've all been here a long time. We understand that's how it works. But every person sitting at this dais was elected by the people of their states. And you were elected not to follow the instructions of Chuck Schumer, not to follow the instructions of Joe Biden. You were elected to represent the citizens of your own states. I've been to the states of every member of this committee. I promise you the citizens of your state would find this a simple question. I expect in a minute every Democrat, like the Soviet Politburo, is going to vote for this judge. Because that's what happens. You're not going to refute the substance of what we said. You're just going to be, we're Democrats, we're voting yes. And part of the reason you are is you're very confident the media back home is not going to ask you about it. I would challenge the Democrat members of this committee. Go home and convene a town hall in your state. Ask the citizens of Illinois, should we confirm to the federal bench a woman who demanded that Connecticut release all violent criminals, all criminals pre-conviction, all murderers, all rapists, all child molesters? Should we make her a federal judge with the power to do that? Ask the citizens of Rhode Island. Ask the citizens of Minnesota. Ask the citizens of Delaware and Connecticut and Hawaii and New Jersey and California and Georgia and Vermont and California again. I guarantee you, I don't care how blue your state is. Your citizens, if you ask them, so what do you think? Someone who thinks we should empty the jails and release violent criminals, should they be a federal judge? Great state of Georgia, the Peach State. I don't think you could find a room of people who would say, yeah, that should be a federal judge. Just about anybody. You can get a bunch of lefty college kids. Ask them, should that be a federal judge? They'd say, of course not. Constitution gives this body the power of advice and consent. But it only works if people have the backbone to use it. If you view your job as I'm a rubber stamp for the Biden White House, whoever they send us, look, the Democrats on this committee have already signed off on 3 nominees of the Department of Justice who want to abolish the police. You've already signed off on a radical judge who describes himself in his own words as a, quote, wild-eyed liberal, says he wakes up every morning motivated by hatred for conservatives. He's a federal judge in New York. God help you if you're a conservative and you're in his court. You go sit there, Your Honor, you realize Your Honor woke up that morning motivated by hatred of you. But every Democrat thought that was fine. That looks like a good judge to us. And you're preparing to move forward on a judge that literally doesn't know what Article 2 of the Constitution is. We've also got another judge whose most significant legal experience was a driver's license revocation proceeding. You all know this is garbage. You know the right thing to do. What it takes is one Democrat to have the gumption to say no. And by the way, all right, y'all are familiar with the little bracelets people wear, WWJD, what would Jesus do? I'm going to suggest to the Democrats you have a version of that. And with respect to the good Lord, I'm not going to invoke his name. I'm going to make a more terrestrial version. I'm going to suggest that you guys wear a bracelet that says WWJKD. That when you're thinking of what to do, ask yourself, what would John Kennedy do? That's a really good test. What would John Kennedy do? And by the way, if these were Trump judges, heck, I'd be here with popcorn watching John Kennedy rip those Trump judges a new one. If they sent a judge that doesn't know what Article 2 is, that person's not becoming a judge. Because John Kennedy actually respects what it means to be a judge. He spent too much time in too many courtrooms to know if you have a jackass who doesn't know what he's doing or an ideologue on the bench, it's bad for the rule of law. And y'all remember, John Kennedy torpedoed Trump judge after Trump judge. We had a lot of great judges, but we had some that weren't great. And the ones that weren't great, the Republicans on this committee said, no, go back and do it again. Is there even a single Democrat who could look at that bracelet, what would John Kennedy do, and say, you know what? A judge who calls for releasing every violent criminal in the state of Connecticut who's on pretrial containment, that shouldn't be a judge. You all know it. The choice you're facing is, well, if I vote no, wow, the White House is going to be really mad. If I vote no, Chuck Schumer is going to be really mad. You know, I'm supposed to follow the instructions of my party. You're United States senators, for Pete's sakes. You don't represent the White House. You don't represent Chuck Schumer. You represent the people in your state. And all of you, the people in your state on this nominee, would look to you and say, if they read this letter, the people in your state would say, when you are voting, you should not just vote no, you should vote hell no. I hope and pray maybe one of you chooses to listen to the people in your state, or if not, you can look forward to when you're back in your state, having constituents read this letter to you and say, why did you think this person should be a judge? I got to tell you, I wouldn't know how to answer that question. Only answer I'd know to give to my constituents is, of course I didn't. She'd make a terrible judge. So do what you know is right.
Anyone else seek recognition? If not, the clerk will call the roll.
Mr. Whitehouse.
Aye.
Ms. Klobuchar.
Aye.
Mr. Cook. Aye. Mr. Blumenthal. Aye. Ms. Arona. Aye. Mr. Booker.
Nomination will be favorably reported to the floor. Next, we have Christopher Fonzone, nominated to be the Assistant Attorney General for the Justice Department Office of Legal Counsel. Does anyone seek recognition on this nomination?
Mr. Chairman.
Senator from Rhode Island.
Just to say that I've made considerable progress with the Department of Justice and will be voting yes in the committee on this individual with the expectation that that progress will continue.
If no one else seeks
Mr.
Senator
Chairman.
Welch.
Mr. Chairman.
Senator Welch first.
Requested documents that they just arrived, and we're in the process of reviewing them, so I intend to vote yes, but reserve my right on the floor. Thank you.
Thank you. Senator Cotton.
I'd like to say a few words about the nomination of Chris Fonzone to lead the Office of Legal Counsel. I don't believe that Mr. Fonzone should be confirmed to this very important and sensitive job. It's often described as the Department of Justice's law firm, and opinions issued by the Office of Legal Counsel are binding authority on the executive branch unless we pass a law or court rules to the contrary. It's not an insignificant job. It requires a very, very important sense of judgment and discernment. Unfortunately, I believe Mr. Fonzone has not shown that sense of judgment and discernment in the past. He worked in Barack Obama's National Security Council. He was well aware of the time that of the threat China posed to this nation, given his work on the NSC. But at the end of the Obama administration, he went into private practice, and in private practice, he willingly agreed to do work for Chinese communist-controlled entities like Huawei. In his nomination hearing for his current role as General Counsel of the DNI, I asked Mr. Fonzone about that representation and whether he could have turned it down within his firm. He said he didn't know. I suppose he never sought to find out. I guess he wasn't interested in knowing whether it was suitable in fancy law firms to decline work for Chinese communist-controlled entities. I suspect very much that it was just fine to turn down work for big tobacco companies or oil companies or other companies that are disfavored by the Democratic Party. But radio silence for Chinese communist-controlled or affiliated companies. Now, despite his work for Huawei, he's been in a very sensitive role at the Office of the Director of National Intelligence, and President Biden wants to put him in charge of legal rulings that could affect the entire executive branch. I think we should all ask ourselves a question, not just about Mr. Fonzone and about this role. Should we confirm people who are well aware of the threat that communist China poses to this country, who have left government, left sensitive national security or foreign policy related positions in the government, and then gone into the private sector where they have worked with Chinese communist-owned, controlled, directed, affiliated entities? If they do, should they be invited back into the United States government, into positions requiring sensitive judgment and trust? I have nothing against Mr. Fonzone personally, and he's far from the only person who has worked in government, left, and done work in private practice for Chinese communist-owned, controlled, directed, affiliated entities. But I do think it's a practice that we ought to frown upon, to discourage, and to encourage people who are in law firms or investment banks or consulting firms or multinational corporations to think twice about willingly working for Chinese communist-controlled, owned, directed, affiliated entities. I think it would be a good thing if fewer people did that, and especially if they came back into the government. That's why I opposed his nomination to his current role, and that's why I will oppose his nomination to this role as well.
Mr. Chairman?
Senator Graham.
Yeah, I will join my colleague, Senator Cotton, in opposing. If you're a foreign country, an ally of the United States, and you use Huawei technology, we tell you we're not going to share information with you, because we believe that Huawei is an extension of the Communist Party, and that if our systems get hooked up to the Huawei system, for lack of a better way of explaining it, you could compromise our security. So we remember calling the Prime Minister of Great Britain at the time when they were discussing this, talking about our policy on Huawei. An ally, no better ally than Great Britain. At the time, a real friend. But I said, we just believe it's not in our national security interest for our allies to sign up with Huawei technology. The gentleman in question, after having been in the Department of Defense and working for the National Security Council, took on work in a firm, part of a firm, that represented Huawei Technologies. I find it hard to believe that we're going to make somebody an OLC lawyer for our government who decided it was okay to work with Huawei Technologies after having been in our government. That's just like bad judgment. So if we're telling our British allies and others, we can't do business with you if you sign up for Huawei, why in the world would we promote somebody who, after having been in the government, decided to represent these entities? I think that's just bad choice, really bad choice.
Mr. Chairman.
Senator Cornyn.
Mr. Chairman, I think Mr. Fonzone's nomination and the points made by Senator Cotton and Senator Graham raise larger questions. I'm thinking, as I heard the comments about the attempts that Senator Grassley, Senator Feinstein, and those others of us on this committee have tried to implement reforms to the Foreign Agent Registration Act. It's a fact that foreign governments, not just friends, but adversaries, hire lobbyists, law firms, accountants, other people here in Washington, D.C., who, unbeknownst to us, are working on behalf of our nation's adversaries. And the reason why is because the Foreign Agent Registration Act is full of loopholes, and it needs to be fixed. We take an oath of office to uphold the Constitution and laws of the United States, not to do the bidding, inadvertently, maybe unwittingly, of our nation's adversaries. This is serious stuff, because our nation's adversaries exploit this loophole in the registration of foreign agents. I'll just give you a quick anecdote. Back 2016, I was one of the chief sponsors of the law that called JASTA, which created a waiver for sovereign immunity for countries that finance terrorist attacks on American soil. This is focused like a laser on 9/11. And the 9/11 families who lost loved ones on that terrible day came to us and they said, we think there were foreign nations who financed a terrorist attack on American soil, which resulted in the death of our loved one. And we'd like to be able to go to court to prove it if we can. And so 2 times, this very narrow waiver of sovereign immunity, foreign sovereign immunity in the JASTA bill, passed the Senate, 100-0, both times. We actually overrode a veto by President Obama, because I think we all felt like this was a compelling case, and that these American citizens who, through no fault of their own, found themselves a victim of a terrorist attack on 9/11 should be able to go to court and seek recourse. I actually had a number of lobbyists on K Street call me and urge me to drop this legislation. They were working for the Kingdom of Saudi Arabia. Now, I'm not passing judgment on the facts, but I do believe the 9/11 families should be able to go to court and prove what facts that do exist, if in fact there was a foreign nation that financed terrorist attacks on American soil. The next thing I knew, I had a group of American GIs, veterans, show up in my office and say, we're here because we think you shouldn't pass this law which would give recourse to the 9/11 families. And we inquired as to, what possible interest could you have in this topic? And they'd been sold a bill of goods. But they knew, and the people who paid their travel and their hotel bills to come to Washington to lobby against this JASTA bill, that if, in fact, members of Congress believe that, hey, this is something that our veterans care about, and they don't want us to do this, that maybe, just maybe, they'd be able to get some traction. Now, they weren't required to register or to let me or anybody else know that they were unwittingly representing the interests, potentially, of a country that financed a terrorist attack on American soil on 9/11. I found that outrageous. I found it downright frightening. So when Mr. Fonzone represents a company, Huawei, which is affiliated with the Chinese Communist Party, and which we have urged our allies around the world not to buy that telecommunications material because it's a backdoor into spying on their communications by the Chinese Communist Party, it does trouble me, as Senator Cotton pointed out, when someone who wants to serve in such sensitive positions has represented them. Again, this isn't so much addressed at Mr. Fonzone specifically, but I wanted to take the opportunity to talk about why this is not a trivial matter. This is a highly significant matter, but it's even bigger than this nomination to this important position. Thank you.
Clerk will call the roll.
Mr. Whitehouse.
Aye.
Ms. Klobuchar. Aye. Mr. Coons.
Aye.
Mr. Blumenthal.
Aye.
Ms. Rono. Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Welch. Ms. Butler. Chair Durbin, on this vote, the ayes are 11, the nays are 10.
The nomination will be favorably reported to the floor. Senator Coons?
Mr. Chairman, I did not vote on the second nominee this morning. There was a period where it was unclear whether members were to be allowed to speak to the nominees, and I requested clarification. You subsequently made clarification that members were going to be allowed to speak to nominees, and you went through the relevant precedent. So I'm prepared to vote for the nominee if you would call the roll again and permit members to speak who did not previously have the opportunity to speak.
Chair entertains that suggestion, and any member who wishes to speak to
Mr. Chairman, could we clarify which nominee we're talking about?
Yomi Lee.
Yumi Lee.
So if there are any senators asking for recognition to speak to the nomination of Yomi Lee before the roll call is called? If not, the clerk will call the roll.
Mr. Whitehouse.
Aye.
Ms. Klobuchar. Mr. Coons.
Aye.
Mr. Blumenthal. Mr. Rono. Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Welch. Ms. Butler. Mr. Graham.
No.
Mr. Grassley.
No.
Mr. Cornyn.
No.
Mr. Lee. Mr. Cruz.
To the authorization for subpoenas relating to the Committee's Supreme Court Ethics Investigation. I'd like to offer a manager's amendment, HEN 23B86, and move for its adoption. Now that Robin Arkley has provided a substantive response to our inquiry, I am no longer seeking compulsory process against him. As his counsel told the Washington Post, quote, "We were treated fairly by the committee." In contrast, Leonard Leo continues to ignore our efforts, and Harlan Crow has refused to provide a sufficient response. All those in favor of the manager's amendment say aye.
Aye.
Opposed, no.
No.
Manager's amendment is adopted. Roll call on the manager's amendment. Secretary, call the roll. Clerk will call the roll.
Mr. Whitehouse.
Aye.
Ms. Klobuchar. Mr. Coons. Mr. Blumenthal. Mr. Rono. Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Welch. Ms. Butler. Mr. Graham.
No.
Mr. Grassley.
No.
Mr. Cornyn.
No.
Mr. Lee.
No.
Mr. Cruz. No. Mr. Hawley. No. Mr. Cotton. No. Mr. Kennedy. No. Mr. Tillis. No. Mrs. Blackburn. Chair Durbin.
Aye.
Chair Durbin, on this vote, the ayes are 11, the nays are 10.
Manager's amendment's adopted. We now turn to.
Mr. Chairman, I have two amendments at the desk.
Well, please let me
Okay.
make a statement. I'm going to recognize Senator Graham on the Republican side for the order that the members on your side will offer the amendments. He has already given me your name earlier, but I want to let you proceed.
Thank you, Mr. Chairman. If it's okay, Senator Blackburn, I think you have a couple amendments. And as we get involved in this process, I just want to, when we did subpoenas of Crossfire Hurricane, one of the most corrupt investigations in the history of the country, can't remember, 16, 20 votes, can't remember what it was. So I'm glad we're having votes. I just want to remind the public who may still be watching this for some odd reason, this is going nowhere. This is a political exercise. And Mr. Chairman, I'm still dumbfounded that after voting a bill out of the committee that supposedly fixes this problem from your point of view, why we haven't brought it up to the floor. I mean, you have a solution, you say it was voted out of the committee and it's never been brought to the floor. You're doing an investigation to fix a problem that you've already had a legislative solution for. What are we, if you want to fix the problem, try to pass the bill that you claim fixes the problem. The reason we haven't voted on that bill, Mr. Chairman, and never will, is because there's just not the votes. This is incredibly, in my view, unconstitutional. So we'll play this game for a while. Nothing will happen. The subpoenas never get issued. The bill never gets voted on, but it's important enough to destroy the committee.
Senator Graham, would you
yield for a
yield to a
question?
question? No. I defer to Senator Cornyn.
We're in the amendment stage.
Would the
only-
senator yield for a question?
Just 1 second, please. We're in the amendment stage. What I'll say to my colleagues is we're going to finish this today. And Senator,
We're going to finish this bill today?
the amendments to the bill today. Senator Blackburn
Wow.
will be the first Republican you want recognized.
Thank you,
I
Mr.
was asked the senator to yield for a question while he had the floor.
Wait a minute,
if
I
I'm not
want to know,
mistaken.
like,
I'll
so
certainly defer to Senator Blackburn,
got
but.
12
but I-
minutes to finish this
I think the
bill?
practice
Well-
here in the Senate is if senators has the floor and another senator asks them to yield to a question and they say, yes, I will, that
Go
then
ahead
that
to Senator
senator
Graham.
has the floor.
yes, you can definitely, well, one, are we going to be able to debate this bill? What happens? What's the game plan?
Depends on
What do you intend to do?
Of course, it's in your hands. 177 amendments are pending. That's not the first time we've had that number before the committee.
We said we're going to vote on it today.
I said we're going to finish the
So
bill
wait,
today.
what does today mean?
Today is
Today at noon?
Thursday.
Is that when we're going to vote on this bill? When are we going to vote on the bill today?
Stay here as long as you wish to offer amendments.
Okay, so we can waive the 2-hour rule.
No, I don't know that the 2-hour rule has been invoked, but you remember we went through this before with Vanita
Okay,
Gupta.
so basically, you're giving us today, which is Thursday. Wow, okay,
Would the senator yield for a question?
absolutely.
These are private citizens that the majority of the committee seeks to subpoena, correct? Senator Graham?
Yes.
Are you familiar with any legitimate legislative purpose for subpoenaing private citizens?
I think this is a charade politically motivated to attack the integrity of the Roberts Court, to act on what they said they wanted to do to destroy Clarence Thomas's reputation. I think if they really cared about the ethics practices of the court, we would be looking into Sotomayor's situation, Justice Sotomayor, where staff members apparently called people, you need to sell some books if she's going to speak. So, yeah, I think this is all politically motivated. I think the two private citizens involved, particularly Leonard Leo, is at the top of the guy I hate most list in the conservative world. I think this is despicable, what they're doing to these people. I think it's bad for the country. I think this is a joke simply because the bill to fix the problem they claim it exists, they won't even bring it up to the floor. So this is an investigation of private citizens, Senator Cornyn, that I think is politically motivated, not legislatively motivated, because if you wanted to pass legislation, you've already done it out of committee. All you got to do is bring it to the floor. You're in charge. So no, I think it's patently obvious. There's no legislative purpose. This is designed to get people they don't like and try to destroy Clarence Thomas.
If the senator will yield for one more question, we heard some discussion about precedent earlier. The chairman cited what he claimed to be a precedent. I'm not clear that that's actually the case, but in other words, that the rule's been violated before, and so now that sets a precedent for that action. It becomes the norm. So what limitation is there on the majority of the Judiciary Committee issuing subpoenas to private citizens for any purpose that they may please?
That's the heart
That's
of
the
the matter.
precedent that will be set, correctly?
Anybody we don't like, for whatever reason, we'll begin to subpoena on a partisan basis. The people I wanted to subpoena were involved in a corrupt investigation conducted by the Department of Justice called Crossfire Hurricane. The court rebuked, the FISA court rebuked the Department of Justice and FBI lawyers for misleading the court. Here, we have efforts to bring in two private citizens associated with Clarence Thomas. There is no effort to go after other situations involving judges that may have done something untoward. So what we're doing now is using this committee as sort of a political vendetta. You don't like a couple of people who are active on the other side, and we're going to subpoena you. Yeah, I really.
And that would be the precedent that would be set.
Yeah, I think so. And I didn't do that. Senator Grassley didn't do that. we're actually worked together to issue subpoena for tech
Sen-
CEOs.
Senator Graham, would you yield for another question?
Yes, sir.
I would appreciate it if you and/or Senator Cornyn could educate me here on the so-called precedent of subpoenaing private citizens. Let me give you an example. I read recently where the FBI it has announced that it is prosecuting a prostitution ring here in Washington, and I understand it may be New York, or New Jersey. And the clients include prominent politicians and generals and lobbyists. And in order for the client to frequent this brothel, the client had to give his name, his address, his social security number, his credit card. Could we issue a subpoena for their names?
I'm sorry. Could you repeat it?
Do I have to repeat the whole thing?
No. I got the
You got the
prostitution
brothel
ring.
part, right?
Yeah, yeah. I was wondering
Okay.
if you said they were subpoenaing me. No.
No,
they're not. Yeah. Okay.
Under this precedent, will we be allowed to subpoena those names?
I don't know where we're going, I guess, Senator Kennedy. I know that the subpoenas were issued in the past that I'm aware of involving oversight function of an investigation by the Department of Justice. I know we've worked together to issue subpoenas to get people before the committee in the tech business who we think the companies in question are doing a lot of harm to the country. Leonard Leo and Harlan Crow are very prominent conservative people. And we're going after, you talk about Leonard Leo, like, where do you get your judges from? We get our judges from conservative people who make recommendations to us. Where do you get your judges from? You have liberal groups, I'm sure, recommending names. This is really dangerous, Senator Kennedy. There are two individuals, one's been working in the committee for 4 months. They want to know anybody you ever saw that ever got on a plane you ever met at the gas station. It's beyond overbroad. It's chilling to me. I have literally begged my colleagues, please don't make me go down this road. Please don't make me have to fight back over this that is not going to advance any cause. You have picked political people you want to please over the smooth and efficient operation of the Judiciary Committee. You've made me and everybody on this side fight back because we believe what you're doing is politically motivated. There's not an ounce of legislative purpose in these subpoenas, because if you really gave a damn about legislation to fix the problem, you would bring the bill up to the floor that has passed this committee. So, yeah, this is really bad, Senator Kennedy. There is no limit to it. I hope you're satisfied over there.
Would the senator
Mr.
yield?
Chair,
Chair will reclaim the time.
Could I-
Chair reclaims the time. I'm sorry, Senator Kennedy.
But I have another question.
Well, I'm sure you have plenty of questions. I recognize Senator Graham to tell the order of Republicans offering amendments. I want to make one statement, and then we'll proceed to ask Senator
it was a good
Blackburn.
question I
I'm
had,
sure it's good.
Mr. Chairman.
All your questions are good. Keep in mind, as we talk about the expanding the limit opportunity under subpoenas and whether we're going too far, we have named 2 individuals who we've worked with for months trying to secure this information. Let me tell you, 2 individuals, that's it, and the subpoenas so far. And I will tell you this too. Contrast that with the Republicans' unprecedented subpoena authorization in 2020 on Crossfire Hurricane. They provided the chair with a blanket authorization to subpoena more than 50 named persons and an unlimited number of unnamed persons. So the sanctity of the subpoena obviously was not the major consideration at that moment.
Can I ask you a question,
Senator
Mr. Chairman?
Blackburn, Senator Blackburn.
Would you yield for a
Well,
question?
wait a minute.
Senator Blackburn.
Senator Kennedy, Mr. Chairman, can I respond to what you said?
Of course you
Because
can.
I'm the one that sought the subpoenas.
Yes, it's true.
We were trying to find out how, in America, the FBI could use Christopher Steele's dossier that was full of lies and garbage to get warrants against American citizens. We're trying to find out how Crossfire Hurricane got off the rails to the point that the FISA court rebuked and issued sanctions against Department of Justice and FBI legal counsel for misrepresenting to the court the true nature of the facts. This is a political effort by the radical left to destroy this court. You have subpoenaed two prominent conservative people. You have ignored other problems with the court that Senator Blackburn would like to bring up to the committee. There's legislation you have passed before you did the subpoenas that would fix the problem. Why would you do the subpoenas after you pass legislation to fix the problem? You have chosen not to bring the legislation to the floor because it's unconstitutional. There is no legislative purpose here. This is politics, it's raw politics, it's dangerous politics, and this committee is taking the country down a very dark and dangerous road. That's the difference.
Will you yield for a question?
Yes.
First of all, Mr. Chairman, Mr. Ranking Member, isn't it true that the committee requested 25 years' worth of documents from Mr. Crow, and Mr. Crow offered 5 years of those documents, notwithstanding the absence of a legislative purpose, notwithstanding the fact that he was under no obligation to do that?
That's correct.
Isn't it also true, Mr. Ranking Member, that on November 9th, 2023, what's that, 3 weeks ago, today, in this very hearing, our chairman, our committee chairman said from this very seat, quote, "It is within the power of the Chief Justice and his fellow justices to solve this problem before noon today, and they should have done so a long time ago." In other words, he was conditioning it upon the Supreme Court issuing its own code of conduct, which the Supreme Court has now done, which I haven't heard anyone describe as inadequate, insufficient. Wasn't that the entire condition precedent for this committee even considering that?
All I can say is this is not about the Supreme Court, the way it operates. It's about the left hating the Supreme Court the way it's constituted. I'm not saying that. That's what they've said. They literally want to pack the court. They want to destroy this court. They want to add members if that's what it takes to destroy it. They want to ruin people's reputations if that's what it takes to destroy it. The subpoenas in question are going after private citizens beyond being overbroad. There is no legislative purpose here.
Would the senator yield for a question?
Yes, I will.
The two individuals that Senate Democrats are targeting, Leonard Leo and Harlan Crow, are both, I believe, extraordinary patriots.
Excuse me, Senator, but I want to make one point clear. Any request for time comes through the chair. I yielded to Senator Graham. He has made his statement. Now, what's happened in the interim, I want to report to the committee so you know exactly where we stand. In the time that I've served on Judiciary Committee and in recent time, the Democrats have never invoked the 2-hour rule on this committee, never, so that we were able to continue our business and finish it. Now, for the second time, as my chairmanship, the Republicans have invoked the 2-hour rule as they did on the Vanita Gupta nomination, which means that we literally have until 12 o'clock to complete our business.
No, we have next week, and we have the week after that, and we have the week after that. What is the urgency here? Give me a break. You got a bill on the floor.
Senator Graham, would you yield to a question?
Please let me finish.
The chair has the floor. We will therefore proceed with a vote on the chair's November 2nd, 2023 motion to authorize subpoenas relating to the committee's Supreme Court ethics investigation. The clerk will call the roll.
I have a point of order, Mr. Chairman. I have a point of order. The chair shall entertain, okay, excuse me. I raise a point of order.
Please proceed.
By limiting, can I raise a point of order? Mr. Chairman, can I please raise a point of order as to what you're doing?
We're on a roll call.
Mr. Padilla.
Under Rule 4, you have a right to have a roll call vote on any debate.
I have a right under Rule 4 to have a roll call vote to end debate. That's in the rule. I'm invoking that now.
So in the middle of a roll.
Yes.
Are you denying me the right to vote to end debate under Rule 4?
Clerk will suspend. The chair makes a motion to suspend Rule 4. Clerk will call the roll.
I object. I asked a roll call vote, please.
Yes, we'll roll call.
So it's a roll call on the motion to suspend. Yep. Mr. Whitehouse.
Aye.
Ms. Klobuchar. Aye. Mr. Coons.
Suspending Rule 4.
So that we can complete the vote.
Mr. Blumenthal. Ms. Arona. Mr. Booker.
This is a vote to end debate, right?
Right.
Mr. Ossoff.
Thank you.
Mr. Welch. Ms. Butler. Mr. Grant.
No.
Mr. Grassley.
No by proxy.
Mr. Cornyn. Mr. Cornyn. Mr. Lee. Mr. Cruz. Mr. Hawley. Mr. Cotton. Mr. Kennedy. Mr. Tillis. Mrs. Blackburn.
Mr. Chairman, Senator Grassley did not give me his proxy. I had bad information. Thank
The
you.
nays are 1.
The question now is on the proceeding to vote on the chair's November 2nd, 2023 motion to authorize subpoenas. The clerk will call the roll.
Mr. Chairman, can I raise a point of order, please?
I'm
May I?
sorry, but we have to proceed with this roll call.
Yeah, I can't raise a point of order before we vote.
Clerk will call the roll.
Mr. Whitehouse.
Go away, go away.
Ms. Klobuchar. Mr. Coons.
You should just leave it.
Mr. Coons. Mr. Blumenthal. Ms. Arona. Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Welch. Ms. Butler. Mr. Grant. Mr. Grassley. Mr. Cornyn. Mr. Lee. Mr. Cruz. Mr. Hawley. Mr. Cotton. Mr. Kennedy. Mr. Tillis. Mrs. Blackburn. Chair Durbin. Chair Durbin, on this vote, the ayes are 11.
The motion is agreed to. The chair is authorized to issue subpoenas pursuant to the motion, and the committee stands adjourned.